And now I'd like to introduce our speakers. Complete biographies are included with today's PowerPoint. Melissa Siebert is a partner at BakerHostetler who concentrates her practice in employment litigation, class and collective action litigation, and employment law counseling. Melissa's combined legal and human resources business experience allows her to provide effective and efficient counsel on a variety of strategic and day-to-day issues. She also has substantial experience in representing employers in labor matters, both as in-house and outside counsel. Joel Griswold is a partner at BakerHostetler. He is a class action litigator and makes it his primary objective to get results for clients with minimal interruption to business operations. In addition to representing companies in class actions, Joel regularly counsels clients on areas outside of pending litigation to avoid and mitigate liability. Bob Brown worked for 20 years at Bell, Boyd & Lloyd and its merger partner K&L Gates in Chicago, where he was dedicated exclusively to the representation of management in labor and employment matters. Bob resigned from his equity partnership in January 2014 to join the corporate legal team of Federal Signal Corporation in Oak Brook, Illinois, where he continues to practice today. And now I'd like to turn the program over to our speakers. The floor is yours.
Hello, everyone, and this is Melissa Siebert. I'd like to welcome you to this very timely discussion of the workplace issues that have been and could be created by the increased legalization of marijuana. This discussion is so timely that we had to update our slides over the weekend to reflect new pending legislation, which we'll discuss with you today. Just a brief introduction of ourselves. As we begin to speak, we'll tell you who we are a little bit. My name, again, is Melissa Siebert. You've heard that I'm an employment attorney. I have an outside counsel and an in-house background, and I have also worked in human resources. So I've seen workplace issues from all sides of the fence. I've been practicing law for over 20 years. This disclaimer slide today is the small print, which tells you that these are our own opinions, not that of our law firms or employers. And we're not intending to give you specific legal advice today or to form an attorney-client relationship via this presentation. If you are interested in speaking with us further, you will see our contact information at the end of this presentation. And this is just a little bit of background about our firm and the locations where we have offices throughout the United States.
So today this is Bob Brown. Today we're going to cover a number of topics. First, Joel and Melissa are going to take us through an overview of current and pending laws regarding both medical marijuana and recreational marijuana use and how those laws have evolved and are continuing to evolve. Second, we'll take a look at how many of these laws provide protection to employers seeking to apply drug testing programs and workplace policies that prohibit testing for positive marijuana or which prohibit the use of being under the influence of drugs such as marijuana. We'll also discuss an increasing number of state laws that provide employee protections related to marijuana use. Third, we'll look at some prior and pending cases and discuss what impact these cases may have on employer practices in their respective states. And last, fourth, we'll talk about real-world applications. What should employers be doing or be thinking about to address the impact of increasing protections for those who use medical marijuana or use marijuana recreationally? Specifically, what are the hot button areas for employers that they may want to address now?
This is Joel Griswold. We've attached a map here for your reference. that identifies states across the country that have currently medical marijuana laws on the books. Those are indicated in the light gray. States that have removed all jail time for possessing small amounts of marijuana are indicated in the slightly darker shade of gray. And states that both have medical marijuana law and have removed jail time for possessing small amounts of marijuana are indicated in the black. States that are shaded in blue are those in which it's legal for adults and is taxed and regulated similar to alcohol, and also states that have medical marijuana laws. Just so you know, this is a source that's been, we took this map from a source at www.mpp.org. And obviously with several states expecting litigation or legislation to be passed in the next year, this map is in flux and subject to change. You obviously feel free to reach out to this source directly as your state is impacted, or feel free to call us.
So breaking down the map that Joel just showed you into numbers, there are now 23 states and the District of Columbia that have medical marijuana statutes. There are 19 states that have additional medical marijuana related bills in process. And there are 2 states where legislation to legalize some form of medical marijuana has already failed in the respective state legislatures. Several things to note about this slide. The medical marijuana statutes differ widely. As Joel just explained, some laws write exceptions into their criminal codes. So what they do is they provide a defense to criminal prosecution based on the use of medical marijuana, and even in some states, more specifically, based on the use of particular medical marijuana extracts. And we'll talk about that in a little more detail in the next few slides. Some laws add to the criminal code changes and are freestanding laws that allow broader medical marijuana use recommended by a doctor. These are often called compassionate use laws, and I know that some of you are from states that have those laws on the books now. Those are laws that more typically have the broad medical marijuana registry card program and the authorized providers of medical marijuana and a very detailed statutory framework around the provision of medical marijuana as well as the taxation of it. If you're interested in reviewing existing or proposed state laws, we'll give you some resources at the end of this presentation to assist you. As Joel mentioned, the map that we just showed you is from the Marijuana Policy Project, and their website's listed on that map. It's very important to note that each of these laws should be reviewed in the states where you or your clients do business. They don't all just make medical marijuana legal. It's legal somewhat in some states depending on the circumstances. So that's a very attorney-like answer for you, but it's one that you should take caution with if you are advising clients or if you're advising your internal partners where you work, that the laws do vary by state on this issue. Now, as of late February, Virginia became the latest state to address medical marijuana usage when its governor signed a law modifying the Virginia Criminal Code to allow users of what is called cannabis oil who have intractable epilepsy to assert such marijuana oil use as a defense to prosecution for marijuana oil possession. So that's one of the states that I just talked about that has a pretty narrow, limited exception to its criminal code only, and only for an extract of medical marijuana. And the 2 states that I mentioned where bills were defeated, they were actually defeated late last month, Mississippi and North Dakota. Those bills did not make it out of their respective committees, and at least one of those bills included restrictions on employers related to their employees' medical marijuana use. There are statutes that do address that in 3 states, and we'll be discussing that in the presentation as well. So many of you may be wondering, how did we get here? Well, what happened and what has happened is that there's changing federal enforcement of federal laws. Since the 1970s, marijuana has been declared a Schedule I drug under the Federal Controlled Substances Act. What this means is that Congress deemed it to have no accepted medical use or use in any medically prescribed treatment. Unlike other drugs, patients cannot legally obtain a prescription for Schedule I drugs. Schedule I drugs also include drugs such as heroin. So from the government's standpoint at a federal level, as of the 1970s, marijuana is not a drug that can be legally prescribed, and it is within the most restricted class of drugs that the government regulates. Now, in the interim, since the 70s, there have been numerous attempts to reschedule marijuana from a Schedule I drug into a lesser category or schedule of controlled prescription drugs. These efforts have not passed federal legislative or court scrutiny. So how did all these state laws and these state medical marijuana and even recreational marijuana laws come to exist? Well, where marijuana, particularly medical marijuana, has made significant advances is in the courts of medical and public opinion. A number of polls indicate that a substantial number of doctors and the public believe that marijuana has medicinal uses, particularly as a palliative or pain-relieving treatment. Federal enforcers such as the U.S. Attorney General continuously have signaled a more relaxed approach to considering marijuana as a Schedule I drug, although it has not been removed from Schedule I. Several years ago, when Colorado passed its recreational use marijuana law, a key deputy told 60 Minutes, a key deputy attorney general told 60 Minutes, we're not interested in bothering people who are sick and who are using marijuana in the recommendation of a doctor. We are concerned with people who are using it as a pretext to become large-scale drug dealers. The FDA has also published statements as recently as early this year indicating an increased desire to research and approve drugs that contain various forms of medical marijuana. The issue now is that only the FDA can truly research medical marijuana because it's a Schedule I drug. So states have stepped into this void. First, they began to create legislation of medical marijuana usage, and they based that legislation on public health and safety grounds. The public health and safety of patients suffering from very severe and chronic conditions or medical situations, their ability to obtain some relief or some treatment through various forms of medical marijuana. They also began to decriminalize marijuana possession in various forms in state criminal statutes, which the states themselves can control. After Colorado, as I said, largely legalized recreational marijuana, the then governor of Colorado kind of explained the trick box that we find ourselves in perfectly. He said, look, federal law still deems medical marijuana use illegal. So folks, quote, don't break out the Cheetos or the goldfish too quickly. So is it time for the goldfish or the Cheetos? Well, it may well be, because on March 10th, Republican Senator Rand Paul and 2 Democratic senators presented a bill called the Careers Bill that, if successful, could result in the passage of the Compassionate Access, Research, Expansion, and Respect States Act. Some of the initially touted benefits of the bill, as currently proposed, are listed on your screen. A key proposal is to move marijuana from that Schedule I status that I discussed to Schedule II status, meaning that physicians could prescribe it. The federal government would essentially be acknowledging the potential medical benefits of marijuana and its use in prescribed medical treatment. The bill also contains important provisions that would allow federally regulated banks to provide loans to medical marijuana businesses and would conceivably draw pharmaceutical companies into the research that is now conducted primarily by the FDA or through complex FDA approval processes. With research and funding potentially set for congressional approval, medical marijuana has begun to look like big business, and I'm sure that all of you have seen some of the articles about that. Now note that this act would only apply to states where medical marijuana has already been legalized. So what the government is doing is leaving to states the ability to decide on a state-by-state basis whether medical marijuana will be legal in their state or not. So that's where we find ourselves today. There is a direct conflict, some believe, between federal and state law. There certainly are federal restrictions that do impact states where medical marijuana is legal. And so some of that impact is listed on this slide. Physicians are not allowed to prescribe medical marijuana, even in states where medical and/or recreational marijuana is legalized. They are only allowed to recommend it as therapy for specified debilitating conditions. So most of these medical marijuana laws have an extensive or sometimes fairly short list of conditions such as epilepsy, cancer, muscular dystrophy, for which medical marijuana can be recommended, but it cannot be prescribed because Schedule I drugs cannot be prescribed. One interesting state that we've just seen hit the books that we'll talk about in a minute is Louisiana. Louisiana and some other states in their proposed legislation on this issue have begun to use the word prescribe and have begun to indicate that medical personnel, practitioners and their adjuncts, so presumably physician's assistants, should be able to prescribe medical marijuana. It's unclear whether that's an intentional attempt to further extend state law or whether it's an attempt, really a half-hearted attempt at passing legislation that can't really be used to effectuate medical marijuana distribution. And that's unclear on that point. As I've said before, the state laws vary on what types of medical marijuana are medically legal. We have seen an increase in legislation that allows the use of marijuana oils or other substances derived from or which compose marijuana or its metabolites. Virginia is one such state. That is somewhat controversial. Several days ago, the Wall Street Journal ran an article about Georgia's law, which is aimed at the legalization, or the proposed Georgia legislation, I should say, that's aimed at the legalization of the use of cannabis oil for specified medical conditions, and the conflicting findings from studies as to whether cannabis oil actually aids, assists, or perhaps worsens the symptoms of juvenile patients who suffer from severe forms of epilepsy. We've also noted most states require patients to register with the state and/or they provide an affirmative defense against state criminal prosecution. Currently, some of the cases that we're seeing are now whether people are allowed to admit into court and other proceedings the fact that they're registered medical marijuana card holders, something that's not currently allowed in certain proceedings in state court. Apologies again. So let's get into some specific protections provided by states. These are some examples you'll see on the slide of states that with statutes that protect patients and or their doctors from penalties, sanctioned, or being denied any right or privilege for participating in a legal medical marijuana program or possessing a valid registry card. So as an example, Massachusetts law prohibits any penalty or denial of rights to a healthcare professional who advises patients about the medical risks and benefits of marijuana and or who certifies the benefits of medicinal marijuana. One thing I should have mentioned about the federal law that was the federal bill that was just proposed, the Careers Act, is that it proposes that the VA, for the first time, that doctors who work for the Veterans Administration hospitals be able to recommend and discuss the benefits of medical marijuana use with veterans suffering from post-traumatic stress disorder. The states are a little bit ahead of the game. They've already protected the doctors and medical care providers who, in medical marijuana legal states, are recommending its use and discussing with patients how to participate in an effective medical marijuana treatment program. And similarly, patients and their caregivers who legally use or administer marijuana can't be subject to arrest, prosecution, or civil penalty in Massachusetts. Michigan, Montana, and Rhode Island also protect patient cardholders from being arrested, prosecuted, or denied any right or privilege simply because they possess a valid medical marijuana registry card. You may be thinking, well, why would that be an issue in a state where medical marijuana is legal? And Joel will take you through a case in a few minutes involving precisely that fact scenario. Is mere possession of a card sufficient reason for an employer to withdraw an employment offer? Other states, such as Illinois, take registry participation or card holder status, as it's called, one step further, prohibiting employers, schools, or landlords from penalizing anyone based solely on their status as a registered qualifying patient or registered designated caregiver. Connecticut law takes it one step further, saying that no employer can refuse to hire, discharge, or penalize an employee if they are a qualified medical marijuana patient or caregiver. That law does not say that employers can't discipline employees who are found to have to test positive on a drug test or to have violated an employer's drug policies or anti-drug policies. So what are the kinds of protections for employers? Many of the states in which medical marijuana is now legal do not extend protections to employees in the workplace itself, and they permit employers to continue their existing workplace drug testing programs or drug policies, prohibiting positive tests and or disciplining medical marijuana registrants for violating workplace drug policies. Illinois law, which is similar to laws in other states, also immunizes employers somewhat for the concern of negligent supervision personal injury claims and identifies characteristics of a reasonable suspicion that employers can use to demand that current employee cardholders submit to a drug test, and Bob's going to be discussing those further. But as you can see, the laws in these states that have legalized medical marijuana are fairly clear that employers are not obligated, number one, to accommodate, which we'll talk about as an ADA issue, or two, to allow. That's the case even in states that have passed recreational marijuana statutes. This is the wording from Alaska's recreational marijuana use statute, which is similarly worded to many of the medical marijuana statutes' exceptions regarding employment. So in other words, employers, for the most part, are still able to decide how they want to address medical marijuana usage or marijuana usage overall in the workplace. Here is where the law may be headed. The following states have passed laws since 2012 that contain specific employment protections for employees. That is Arizona, Delaware, and Minnesota. These states carve out safe zones for employees who are medical marijuana card holders and who may be participating in an approved medical marijuana registry. As an example, Arizona's law prohibits an employer from discriminating against someone with respect to hiring, termination, or discipline based both on their status as a cardholder and a positive drug test for marijuana components or metabolites unless the patient used, possessed, or was impaired by marijuana on the premises or during the hours of employment. To repeat, these states protect employees with medical marijuana registry cards from being disciplined, terminated, or failing a drug test unless, for marijuana, unless they used, possessed, or were impaired at work or during working hours. So 15 states plus Texas, and this is again a recent add because the Texas legislation was literally just proposed, the bill was just put up on March 13th of this year, now have or have had legislation pending to legalize some form of medical marijuana or to increase medical marijuana covered uses pending in 2015. And these are some examples of the states. Some of these states are double counted in that Georgia is a good example of pending legislation in two areas. There is one bill pending now that I discussed to increase, to allow the approved use of marijuana extracts and to approve the use of those in a broader array of debilitating conditions. The second type of bill that's pending in Georgia is a decriminalization bill to allow people to possess cannabis oil or to permit them a defense for the possession of cannabis oil if they are an authorized user of that oil. And here's the last form, which I think I've covered for you fairly excessively. These states have legislation pending, these following states, that would allow the use of a limited form of marijuana-derived products with lower levels of THC, the ingredient in medical marijuana that's believed to provide the medicinal benefits. And so these states are only allowing the use of this cannabis oil. That's what they're proposing. And as I said, Louisiana, we're not sure what's up with Louisiana yet. We cannot tell whether the language that they've inserted in their bill which would allow physicians to prescribe marijuana, is an attempt to expand the frontiers of state legislation beyond what is currently permitted by federal law, or whether it's a bill killer at this stage of the game. So what this becomes now is a states' right issue, and it becomes a voting issue. And so many organizations, such as the Medical Marijuana Policy Project, are out smoking the vote. They're teeing up the medical marijuana issue for voters, and that includes Texas, which is considering decriminalization measures. And while the decriminalization bill was pending, which was just proposed last year, as I said several weeks ago, another Texas lawmaker proposed a bill that would establish a very similar medical marijuana program to that existing in Illinois and other states, with a full registry and a full complement of approved uses for marijuana. What do the polls show? There are quite a few polls that have been taken that appear to show that a majority of Americans favor legalized medical marijuana. One of the slides that we received from our Denver office purported to claim that more Colorado voters voted on the decision of whether or not to legalize recreational marijuana than voted for the president in the last presidential election. So I'm not sure what that says either about the president or the voters or the popularity of medical marijuana, but that's a point worth making. It's an issue that crosses party lines. The medical marijuana bill at the federal level is getting quite a bit of attention from both sides of the House, and one of the key selling points is this concern about being able to potentially prescribe medical marijuana or derivatives to veterans who are suffering from PTSD. That has a very public appeal to both sides of the House. And we would be remiss if we did not cover recreational use, which is really called adult use legalization. And as you can see, 4 states and the District of Columbia have taken it one step further and have largely legalized marijuana. And what does that mean? It means that it's a regulated commercial exchange. So laws regulate and tax marijuana in a manner similar to alcohol. Adults age 21 and older can use marijuana for any purpose, and it allows for personal cultivation, retail businesses, and tax assessment. Who is on the cutting edge of that brigade is the District of Columbia, which is ironic to say the least. The District of Columbia, on November 4th of last year, D.C. voters approved what's called Initiative 71, and that legalized the limited possession and cultivation of marijuana by adults 21 or older. Now, Congress has to review District of Columbia ordinances or initiatives, and the review period for this particular initiative ended on February 26th of this year, at which point it became law in the District of Columbia. Now, the initial response of recreational marijuana use proponents has been somewhat tempered by the fact that Initiative 71 doesn't allow for legal sales, doesn't change federal law, and that's important when one considers that much of the District of Columbia is composed of federal land. So not easily thwarted, the D.C. Council members introduced a bill on January 5th that would create the commercial infrastructure for the sale of small amounts of marijuana and hashish. Now, also, the D.C. Council has upped the ante. Last year, an emergency temporary act was proposed and subsequently enacted that prohibited pre-offer, pre-hire marijuana testing. So basically, it provided that an employer can only test a prospective employee for marijuana use after a conditional offer of employment has been executed, unless otherwise required by law. And now the D.C. Council has further upped the ante. They've proposed an act that would entirely prohibit pre-employment testing for marijuana except where required by law. So where does this leave employers? Well, still, as we've said before, most medical marijuana laws currently expressly exempt employers from requiring accommodation of use by employees, which also translates into accommodating employee use. And they also still allow employers to ban possession, use, being under the influence, sale on their premises. This trend has held true for recreational use laws, but as you'll see, as Joel's going to discuss, some of the cases in the area of private rights and employment protection may be on the rise, as well as those statutes that I showed you where there are some current protective measures for employees who test positive on drug tests. And as you can see from the Careers bill, that could signal a sea change in federal law, which would certainly open the floodgates to more state legislation in this area.
Okay, so let's talk a little bit about how the courts have been interpreting this myriad of statutes and regulation in light of the fact that this is still, folks, something that's illegal under federal law, whether it's recreational or medical, it's something that's illegal. The cases, as an overview, have been reflecting that the courts are very cognizant of the fact that state law cannot completely legalize marijuana. They need the federal law to change in order for that to happen. So far, the courts have been following the national trend of treating the use of medical marijuana similar to the use of other illegal drugs. And they've been allowing employers to terminate employees who violate their drug policies despite state laws allowing marijuana use. You look at the federal law, I mean, the ADA explicitly excludes the use of illegal drugs from its coverage, which would include medical marijuana, as medical marijuana remains illegal under federal law. The ADA does not prohibit an employer from terminating an employee or taking some other form of adverse action on the basis of the illegal use of drugs. So what have the plaintiffs been doing? Medical marijuana users have filed employment discrimination lawsuits in states including New Mexico, Maine, Colorado, Michigan, California, but really only a handful of the 23 states that have legalized medical marijuana thus far have anti-discrimination provisions in their state statutes. So plaintiffs have been getting creative. And one of the things they've been arguing is that, one, the state statute itself provides or protects the employee from any adverse action by their employer. And a second major argument that plaintiffs have been falling back on is, even if the statute itself does not specifically or expressly protect them, the statute provides a general public policy that would prohibit termination of the employee or an adverse action against the employee for the medical use of marijuana. So let's take a look at some of the cases that have come out. In Boehner dealt with unemployment compensation benefits, and the main question addressed there was whether an employee terminated for testing positive for marijuana in violation of an employer's zero-tolerance drug policy may be denied unemployment compensation benefits even if the employee's use of marijuana is a medical use. The plaintiff in that case was employed to sweep a mall in Denver, and the employer had a zero-tolerance policy that said, quote, if a current employee is substance tested for any reason and the results of the screening are positive for illegal drugs, the employee will be terminated. The employer ordered a random drug test, and the plaintiff failed. The plaintiff did not have a registration card, but did have a physician certification form. The employer did not dispute that the plaintiff obtained and used marijuana for severe headaches, pursuant to the physician's recommendation. The employer did not contest that the plaintiff's eligibility to receive a registration card was valid. And the employer did not argue that the use of marijuana negatively impacted the plaintiff's job performance at all. Regardless, the deputy denied the plaintiff's request for unemployment. The hearing officer reversed that, finding that, 1, there's no evidence the plaintiff is ineligible for a medical marijuana license, and 2, no evidence that the use of marijuana negatively impacts performance, and 3, that the plaintiff has a constitutional right under the state law to use marijuana. Now, this went to court. The Court of Appeals reversed the hearing officer and affirmed the panel. And in so doing, the court said the presence of medical marijuana in individual systems during working hours is a ground for a disqualification from unemployment, not shielded by Colorado's medical marijuana amendment from being at fault for separation from employment and could be disqualified. Colorado's unemployment provisions provide that, quote, the presence in an individual system during working hours of not medically prescribed controlled substances is a disqualifying event, of not medically prescribed controlled substances. Under Colorado law, a physician does not prescribe marijuana, but may only provide, quote, written documentation stating the patient has a debilitating medical condition and might benefit from the medical use of marijuana. In fact, the physician certification form expressly states that, quote, this assessment is not a prescription for the use of marijuana. Accordingly, because marijuana could not be prescribed, it was something that was actually identified specifically in Colorado's unemployment provisions as something that was a disqualifying event for the purpose of receiving unemployment compensation. The court then rejected the plaintiff's argument that the use of marijuana is somehow a constitutional right under state law. Explained that the Colorado Constitution does not give medical marijuana users the unfettered right to violate employers' policies and practices regarding the use of controlled substances. In particular, noted that the Colorado Constitution provides that it shall be an exception from the state's criminal laws for any patient or primary caregiver in lawful possession of a registry identification card to engage or assist in the medical use of marijuana, with some exceptions. It also noted that beyond being limited to the criminal context, that it limited the amounts of marijuana that a patient could use. And it also said that specifically in the employment context, nothing in this section shall require an employer to accommodate the medical use of marijuana in any workplace. Reading all of these provisions of the Constitution together, the court determined that the medical use of marijuana provisions in the Colorado Constitution do not provide for some unfettered right or expansive right to use marijuana free of any adverse consequence from its employer. It's very limited, just in the criminal context. Okay, let's take a look at Coates. Coates raised the issue of whether terminating for failing a drug test when used off the premises is discriminatory. Is it unlawful discrimination? In particular, the court there asked whether federal prohibited but state licensed medical marijuana is a, quote, lawful activity under Colorado's lawful activity statute. Plaintiff was a quadriplegic in this case who was licensed to use medical marijuana under the medical marijuana amendment that we previously discussed. Employer conducted a drug test and plaintiff failed. Employer terminated him for failure and for no other reason. The plaintiff sued under Colorado's lawful activity statute, which prohibits an employer from discharging an employee for, quote, engaging in any lawful activity off the premises of the employer during non-working hours, subject to certain exceptions. The employer moved to dismiss, arguing that the use of medical marijuana was not a lawful activity because it's prohibited under both state and federal law. the trial court dismissed, citing Boehner, held that the medical marijuana was not a lawful activity because the amendment did not establish a state constitutional right to state licensed medical marijuana use, but rather created an affirmative defense from prosecution for such use. The appellate court affirmed on different grounds. Dusting off its Black's Law Dictionary, the court explained that, quote, lawful means something that is, quote, permitted by law. Earth-shattering, right? Because activities conducted in Colorado are subject to both state and federal law, for an activity to be lawful in Colorado, it must be permitted by and not contrary to both state and federal law. Since the use of marijuana is prohibited by federal law, it is not lawful within the meaning of Colorado's lawful activities statute. This case has since been taken up by the Colorado Supreme Court when an argument was this past September. Decision has not yet come down, so stay tuned. Here's an interesting one. In Callahan, this is a suit that was recently filed, and we'll see how this shakes out. But basically, the question posed in Callahan is whether a refusal to hire because an employee holds a medical marijuana card is prohibited. Is it discriminatory within under at least Rhode Island's Medical Marijuana Act? Rhode Island's Medical Marijuana Act provides that, quote, no school, employer, or landlord may refuse to enroll, employ, or lease to, or otherwise penalize a person solely for his or her status as a cardholder. In this case, plaintiff is a University of Rhode Island student. She needed an internship to graduate, and was in the course of applying for an internship with an employer called Darlington Fabrics. She alleges that Darlington Fabrics rescinded a paid internship offer to her because she was a registered medical marijuana cardholder. Specifically, the plaintiff alleges that she was going to be given the internship until during a meeting with an HR representative, plaintiff disclosed that she suffered from migraines and used medical marijuana to treat her condition, but that she would not bring marijuana with her onto the premises or show up for work after having taken marijuana. A few days after the meeting, the representative contacted plaintiff and told her that Darlington would not be offering her the internship because of her status as a medical marijuana patient. Now, again, these are the allegations in the complaint, and they're subject to challenge, and obviously we'll see how things play out and at the end of the day, but this is at least what's being alleged. The local ACLU filed suit on her behalf, and this case really provides a unique opportunity here to address anti-discrimination provisions in Rhode Island's medical marijuana statute. Of particular interest is the language solely. Does the statute's language solely for his or her status as a cardholder mean that an employer could lawfully make a decision because of cardholder status, so long as there's at least one other reason for the decision? We'll find out, and we'll stay tuned. Another case that we're still waiting to see how it ends is Sheppard versus Coles. This case raised the question of, can an employer terminate an employee for their off-duty use of medical marijuana? The case was filed in California. State court removed to federal court. In the case, the plaintiff was employed as a material handler. The plaintiff alleges that he was diagnosed with acute anxiety and that his primary care physician agreed with a local clinic's determination that the plaintiff would be a good candidate for a medical marijuana prescription. The plaintiff was issued a medical marijuana prescription by a medical marijuana dispensary under California's Compassionate Use Act. The plaintiff was injured at work and was advised to go to the employer's health care provider to get medical treatment. Under the employer's policy, plaintiff alleges that employees must submit to mandatory drug screening when they're injured at work. Plaintiff alleged that his drug test came back positive for marijuana metabolites. The plaintiff also alleges that he was then called into a meeting with his manager and an HR employee, during which he informed them of his positive test, and that was as a result of medical marijuana use, and that he showed them his prescription for the same. The employer allegedly terminated the plaintiff a week later, and plaintiff alleges, filed suit alleging claims under the California Labor Code Section 233, disability discrimination violation of California's Fair Employment and Housing Act, invasion of privacy, and wrongful termination in violation of public policy. Here's an interesting twist. Unlike most of the employers that we've seen adopting zero tolerance policies for drug use, the plaintiff in this case alleges that that the defendant actually had a policy that provided, quote, no person will be discriminated against in hiring, termination, or in imposing any term or condition of employment or otherwise be penalized based on either A, the person's status as a registered medical marijuana cardholder, or B, a registered medical marijuana cardholder's positive drug test for marijuana components or metabolites. The defendant has filed an answer to the complaint, which made a general denial and raised several affirmative defenses, including that the plaintiff is not a qualified individual with a disability under the FEHA, and that the decision to terminate was based on non-discriminatory and legitimate business reasons. Again, this case has been removed to federal court, but as of yesterday, the docket does not reflect any further activity on it. Again, another one we'll just keep our eye on and see how things unfold. As you can tell, this issue we're discussing today is in flux, and the litigation that we're seeing is only going to increase, and we'll see how things go in the future. Another California case that probably will have some bearing on the outcome of Sheppard is Ross. In Ross, plaintiff suffered from strain and muscle spasms in his back as a result of injuries he sustained while serving in the U.S. Air Force. He was a qualified individual with a disability under the FEHA and received governmental disability benefits. The plaintiff's physician recommended that he use medical marijuana to treat the chronic pain under California's Compassionate Use Act. The plaintiff started using medical marijuana. He was offered a job as a lead systems administrator, and his employer required a drug test. Before taking the test, the plaintiff informed the clinic of his use of medical marijuana and gave a copy of the physician's recommendation to the clinic. He began working. The test came back positive for THC a few days later. He was suspended and then terminated because of his marijuana use. The plaintiff alleged that since taking medical marijuana, he has worked in the same field and did not affect his ability to do the essential functions of his job. He sued for violation of the FEHA and for violation of public policy. The Supreme Court of California affirmed the lower court's dismissal of the complaint. In so doing, the court explained that nothing in the text or history of the Compassionate Use Act suggests that voters intended the measure to address the respective rights and obligations of employers and employees. The court explained that no state law could completely legalize marijuana for medical purposes because the drug remains illegal under federal law, even for medical users. The FEHA does not require employers to accommodate the use of illegal drugs. Likewise, the court determined that the employer's decision not to accommodate the plaintiff's marijuana use does not implicate plaintiff's right to refuse medical treatment. Put plainly, the court stated that there is no right to use marijuana free of hindrance or inconvenience. A couple other cases that are notable and actually have we actually have a resolution on her. Casillas out of Michigan. In that case, the Sixth Circuit upheld Walmart's termination of an employee in Michigan who tested positive for marijuana after an on-the-job accident. Walmart maintained a mandatory post-accident drug testing policy and a zero-tolerance drug policy. Upon notice of his failed drug test, the employee presented Walmart with his medical marijuana registration card, issued pursuant to Michigan law, and explained that he used the drug off-site to treat his sinus cancer and inoperable brain tumor. Walmart terminated the employee in accordance with his drug policy. The employee brought suit alleging that his termination violated the Michigan Medical Marijuana Act. The employee argued that the Act's protections for medical marijuana users extended to protections from discrimination by private employers. The Sixth Circuit disagreed, finding instead that the private employers were not regulated by the Act, and further that the Act only gave medical marijuana users protections from state actions. It did not grant them a private right of action regarding medicinal marijuana use. In Oregon, the Oregon Supreme Court in 2010 addressed a situation in the Emerald Steel case in which an employer discharged an employee for medical marijuana use, finding the employee was discharged because it was illegal under federal law use of marijuana. The Oregon Supreme Court found that because the employee was currently engaged in illegal use of drugs and the employer discharged him for that reason, the protections of the Oregon Disability Discrimination Law do not apply. Emerald Steel kind of got to the issue that a lot of these courts have skirted to some extent, and that is, whether federal law is actually preempting state law. Again, most of these cases we've talked about have been able to basically decide the plaintiff's allegations and their claims by looking at the plain text of the statute at issue in conjunction with some of the legislative history, and oftentimes they will actually look at the voters' pamphlets that went out prior to the adoption of the legislation at issue to find out what the intent was behind the legislation. By doing that, they've been able to narrow the scope of these medical marijuana statutes to something that either only applies to criminal acts, only applies to the state, or otherwise does not expand state law to be necessarily in conflict with federal law. And by doing so, they've been able to avoid taking head-on the preemption issue. That likely is going to be something that's unavoidable in the future, and we'll kind of stay tuned to see how that's addressed. In Roe, the Washington's Medical Marijuana Act does not create a private cause of action for wrongful discharge of employee who used marijuana. Again, kind of staying consistent with other cases we've just discussed. One thing I will talk about, just we've talked a little bit about whether these employees can raise claims for discrimination or somehow seek protection under their respective state laws when they suffer adverse consequences at work. One thing that we should keep in mind, and really has not been addressed yet and likely will be, is whether associational discrimination claims could be made going forward. It's an area of law that's been growing recently and may present additional challenges for employers in the context of medical marijuana laws. Associational discrimination claims really focus not on the employee's protected category, race, disability, gender, etc., but on a person's association with someone in a protected category. For instance, employers may have employees who report to work possessing marijuana for someone else, for someone with a disability, someone from whom they care, and they may smell marijuana because they're providing care for somebody who's using medicinal marijuana, or even be under the influence themselves, for instance, by being in a room or by virtue of caring for somebody with a disability and who's using medicinal marijuana. The ADA, while does not protect those who are engaged in illegal drug use, does prohibit associational discrimination. And usually these cases are brought under a couple different categories. One is a case involving expense, meaning that, for example, an employee is discriminated against based on the increased cost of their family member's disability to the company health insurance plan. Another example is a disability by association, meaning, for example, that an employee is discriminated against because of concerns that they may also be infected or afflicted with the disability of the person with whom they associate who has that disability. And third, distraction, which would encompass discrimination based on the assumption that an employee will be inattentive to their work or absent from work due to the disability of the person with whom they associate. There does not appear to be the same obligation pursuant to the ADA, however, to offer employees who associate with disabled individuals the same reasonable accommodation protections as an employee would need to offer a disabled employee directly. Under current ADA case law, as well as under certain state medical marijuana laws, there's no obligation to accommodate an employee's need to possess marijuana on site or to care for a family member. So we should be mindful that an employee terminated for smelling like marijuana may have a claim of associational discrimination. If you can establish he was terminated because of association with a disabled individual who is using medicinal marijuana and not for some other lawful reason. Again, this is something that has not been settled by the law. In fact, we're still kind of waiting to see if these claims start being filed and if they gain traction, but certainly worth keeping in the back of your minds going forward. The CARES Act, which Melissa discussed, and in the Coates case, which I covered and is currently pending in front of the Colorado Supreme Court, are certainly noteworthy and could be game changers in terms of the landscape. Legal conduct statutes are going to be the next area of focus to keep an eye on. Again, if there's a change in federal law that somehow legalizes marijuana, certainly the disposition of cases we've seen under lawful activity statutes is likely to change. And as Melissa pointed out, the legislation is becoming increasingly liberal. Again, what the cases have shown is that this is still, whether it's medical or recreational, it's still illegal under federal law. And federal law preempts state law. The plain language of laws, so far has enabled courts to avoid addressing the preemption issue, but it is there, and they can fall back on that if they need to. And obviously, to the extent that employees are engaged in, involving using heavy machinery, involved in activities that would impact the safety of others, there's always the argument that no accommodation can be made for people who have these drugs in their system, whether it's for medicinal or recreational purposes. And with that, I'm going to turn it over for some real-world application from Bob Brown.
Thanks, Joel. This is Bob Brown. So it's been a while since we've been introduced. Just my background, I am currently an in-house corporate counsel for Federal Signal. We're an international company. We manufacture a variety of products. We focus on safety signaling systems and also various cleaning apparatus and systems. We have these products are used in major manufacturing, mining, and refining environments. We have about 2,500 employees in 6 countries, and we're across a variety of the states: Alabama, California, Illinois, Texas, to name a few. And my background is employment law. And these issues, we're seeing these issues arise more frequently. I wouldn't say on a daily or even a weekly basis, but we are seeing these issues more frequently than we did a few years ago, as you might expect, given all the legislation and case law that's evolving. So the first issue I want to talk about is drug testing. And it seems to me that the discussion that you need to have is what is our culture? What are the particular needs that we need to address? And how is the drug testing policy conducive to furthering those needs and interests? So it is a real discussion that you've probably had already. If you haven't, it would make sense to have that. Identify the concern areas and then adopt a strategy and a policy to address the concern. You've heard reference to zero tolerance drug policies. Certainly based on the case law that we've seen, zero tolerance policies are holding tight for now. And at the same time, however, it's pretty clear based on all the material that we've covered today that public opinion has changed. So too has the legal landscape. And whether or not a zero-tolerance drug policy, while it may remain a viable strategy from a purely legal perspective at the present time, it's certainly at odds with the intent of a lot of the legislation that we've seen, and it's at odds with public opinion. I would have to caution that in states that Melissa discussed where drug test results cannot be considered, and in states that have largely legalized marijuana, that's a tougher call. There's a handful of those states, and essentially what that boils down to is how insistent are we going to be as a company, and as we try to further our company culture, is it worth the risk? Do the litigation math and determine whether the cost of increasing challenges to zero-tolerance policies are worth it. One thing that Melissa had alluded to was the concept of, as in the case with alcohol, where states have come up with an impairment measurement, particularly in the motor vehicle area. 0.08, I know, is the alcohol limit in Illinois. Whether or not it's viable to consider an impairment measurement, and what that impairment measurement would be, largely unclear at this point, but it's something worth keeping abreast of, and consider adopting some sort of cutoff level for a drug test result that would suggest impairment while working or while performing work activities. Again, I don't have a number, a test level. I do know that in the past, employers have gone so far as to test hair samples, which can detect marijuana smoked, months in advance. And you get a positive test on that type of drug test. The person hasn't caused an accident. Maybe it's a random drug test or some other. I think that's a situation where you got to step back and really do the quote-unquote litigation math. The Coates case that Joel discussed, again, that was a case where the individual was terminated for inactive THC, which would indicate a very low level of the presence of marijuana metabolites. That's a case that we all should be watching very carefully. If that Supreme Court, Colorado Supreme Court decision comes out in favor of the plaintiff, employers in states where medical marijuana is legal and which have a lawful use of products, lawful activities outside of work statutes, Illinois has such a statute. Perhaps this mechanism that I'm suggesting of having a cutoff for inactive or active levels of marijuana might thread the needle. I'm going to advance this. Workers' compensation, unemployment. With respect to workers' compensation, it makes good sense to know the workers' compensation drug testing procedures provided by your state or in your policy. In Illinois, employees are now required to take a drug test if injured at work. The Illinois medical marijuana statute supports this finding, including language that allows a conclusion of at-work impairment if there is injury to the individual or to others, or if there's reckless operation of machinery or equipment or disregard for safety. What it also creates, however, is an appeals process. How that process will work is at this time unclear, and it could quite possibly be unfavorable if it tends to delay post-accident drug testing. With respect to the issue of employers having to pay for legally permitted marijuana treatments, the short answer is no. You don't have to pay for that at this time. There was a decision in California, of all places, where the California Workers' Compensation Appeals Board issued a panel decision, and they reversed a workers' compensation judge's finding that an injured worker was entitled to reimbursement for self-procured medical marijuana. The rationale largely hinged upon the classification of marijuana as a Schedule I drug per the Federal Controlled Substances Act. So at this time, you're not paying for legally permitted marijuana treatments, and that could all change. We'll have to stay tuned. With respect to unemployment, the Colorado case came out in favor of the employer after a lot of litigation. If they're terminated for, and again, I think you really need to focus on that last quote, not medically prescribed controlled substance in their system. Again, it can't be medically prescribed because the current federal law does not allow a medical prescription, notwithstanding what the states say, but it does not allow a medical prescription for marijuana. So on the unemployment front, employers are holding firm. So the ADA, Joel talked briefly about the ADA, and the central question is, must we as an employer allow employees with debilitating conditions the accommodation of using medical marijuana? I mean, we do offer accommodation for a lot of things, not just disabilities, religious accommodations with prayer rooms, all types of accommodations. Medical marijuana is not one of them. Again, the ADA is a federal statute. It's still a Class I drug. The cases so far have come out in favor of the employer, and unless there's a change to federal law, I would expect that trend to continue. The caution here is that if you do have somebody with a debilitating condition, you just got to remember that you're going to have to address that disability. And we know that the ADA has been interpreted by the EEOC in recent years quite expansively. What that means is you kind of have to set aside the issue of the use of medical marijuana and focus on the debilitating condition, and you're still going to have to provide an accommodation for that. And whether or not you accommodate for medical marijuana is a business judgment, but it's certainly not required by current law. Bear with me for 1 sec. So Illinois, and we've talked about this, but in Illinois, it does allow medical marijuana to be used for debilitating conditions, cancer, muscular dystrophy, MS, Parkinson's, and seizures, and epilepsy. These conditions, while you don't have to allow a medical marijuana accommodation, these conditions would also qualify as disabilities under the ADA. So again, just a cautionary reminder, don't forget that you'll still have an obligation to engage in the interactive process with employees who have these conditions to assess what other accommodations are reasonable and should be offered. So what keeps employers up at night on this issue? I think one of the lessons from today is this is a shifting environment, and it's shifting on an almost weekly basis. So what gives me the greatest concern is when I'm making a decision about how to address a particular situation that that I have the most recent information, and I'm fully abreast of what's going on in the various different states. As I mentioned, my company has employees throughout the United States. And, it may not be a one-size-fits-all approach. You're going to have different impediments to implementing your corporate philosophy in one state that you may have in another, which leads to my next concern, not just staying abreast of the law. With a large organization and many people making decisions, most of which come through me when it comes to legal issues concerning employees, particularly drug-related issues, is making sure that you have a consistent application. And that's true in any employment decision-making setting. Having a team, which we do, that is consistent and making decisions on a consistent basis. Where you get in trouble, just like with the other anti-discrimination statutes, is when you have inconsistent application. So with respect to the last question, pre-employment drug tests, are they going the way of pre-employment background checks, which we know is restricted in many states, including Illinois? And my personal view is I don't think pre-employment drug tests are going in that direction. There are a handful of states where it's occurred. And there's good reason for pre-employment drug tests. And again, that's an assessment that you need to do of your company and what you're trying to protect against. In a manufacturing environment, you've got lives are at stake. Your first priority is safety, and your second priority is safety, and it's your third priority too. So if that's the hand that you're dealt, it seems to me it might make sense to run the risk of a lawsuit from a non-hire, the result of a drug test, than putting people's lives at stake. And this is, perhaps my position is emboldened by the fact that the decisions thus far have come out the way that they have. Again, getting back to assessing your culture and what you want for your company, I think that's critical. And if you're in an office environment and you're not a manufacturing facility, pre-employment drug testing may be of limited value to you. If you've got people working on oil rigs and who are manufacturing products and operating machinery, that's a different analysis. So turning now to suggested best practices. Certainly review your substance abuse policies, clarifying whether marijuana, including medical marijuana, is a prohibited substances. It's conceivable that your substance abuse policies are quite old and may not address marijuana. Now may be the time to address that. You can consider clarifying whether you want to accommodate medical marijuana and by what means. Double-edged sword, again, getting back to assessing your culture. If you decide to be lax on medical marijuana, you've always got the risk of a negligent hiring lawsuit. So it's kind of a damned if you do and damned if you don't scenario. And the negligent hiring lawsuit would look something like, well, you permitted this person medical marijuana breaks, and you didn't drug test and address the person sufficiently, and lo and behold, this person caused an injury to my client. And that's a case that you could run against some very significant agita or angst from the jury. That would be a tough sell in front of a jury. I wouldn't want to defend that case. Review your workplace safety standards. Again, make sure they're consistent with your corporate philosophy on what you're trying to do and accomplish with your drug policies and views. As I talked about before, I'm going to advance this to the next slide. Make the decision on drug testing after fully assessing your corporate culture and what you're trying to protect and what you're trying to do with drug testing. And consider this clarification of what's a hot screen. If it's a hair sample and the person was using it recreationally or for medicinal purposes months prior and has an explanation for the usage, consider whether you want to have levels similar to the alcohol levels to clarify what's a hot screen and what you're going to take action on. Communicate with employees. And I guess this point really gets to what's the culture. We know the legislators, in deference to public opinion, have become much more liberal with respect to marijuana usage. Communicate with your employees. Get a sense for what, if you have a draconian drug policy, how that's going to impact your employee retention. And vice versa, if it's too lax, how is that going to impact your employees' safety concerns? As parents, we're all probably going through similar issues, whether we're sending kids to Colorado and Washington, Oregon, or Colorado, where marijuana usage is legal. These are discussions that you're having with your kids, with your spouse. I think it's important, from an organizational perspective, to have a similar dialogue with management and the employees, again, without forgetting the safety risks that are presented by any drug usage during working hours. Educate supervisors on how to recognize substance abuse and impairment. And here's the last point, it's probably the most important. Be consistent with discipline and termination actions for violations. Treat similarly situated employees the same. I think the only caveat to that would be an employee in Colorado is probably not similarly situated to an employee in another state. Okay, I think at this time we're going to open it up for questions and answers. These have been submitted online, and there's a number of them, so we're not going to be able to get to all of them, and we'll address your questions. We are scanning our list of questions, and we hope to get to them as many of them as we can.
Okay. We have a question from an attendee about Florida's bid to legalize medical marijuana that had failed last year. Is there much chance of it passing this year? We did promise you at the beginning of the presentation some resources. One of the most up-to-date resources on the status of pending legislation and what bills have been proposed or might be proposed for us in preparing for this presentation has been the Marijuana Policy Project, and we've also used a site called procon.org, and that's one of the sites that really presents all the laws, pro and con, in this area and some more recent updates. It's a good resource for those of you who are both wondering, okay, I didn't see my state on one of these slides, or Melissa, Bob, and Joel didn't talk about my state or all my states, where can I go? Those are two areas to go. One caution for those of you to whom this area is new, many of the pro-medical marijuana sites do not view these cannabis oil legislation as medical marijuana legislation. They don't feel that that's complete enough. So I would caution you, if you're looking at some of the sites, make sure if you see a bill pending that you look through it fully to really understand what it's attempting to legalize. Procon.org may be a little bit better on that front as far as being able to present to you states that have legislation that doesn't entirely legalize medical marijuana, and there's a place on their website for that. You've asked us, hey, after being hired, can an employer give the new employee a drug test? That's a good question, and I think Bob's point about the Illinois statute's definition of impairment, when you can test a medical marijuana cardholder in Illinois who you feel may be actively impaired, is really a sea change in the law for us Illinois employment law practitioners. There's no reasonable suspicion requirement for drug testing or alcohol testing in Illinois. But what this statute appears to say is that you can test a medical marijuana cardholder who you believe is impaired, but it gives you a lot of criteria to use to do that assessment. They're pretty broad criteria, but they're criteria that didn't exist before. And employers would be well advised to fall within those if they're going to do a reasonable suspicion test. As Bob pointed out, that same statute also contains a very vague reference to an employee registered cardholder having the ability to appeal a reasonable suspicion testing decision, which could, as Bob referenced, sometimes delay the testing that an employer might want to do. It's very unclear how to address that issue here in Illinois. We're scrolling through questions. We apologize for the delay. Not on the side. Can we see 21? Yeah.
There was one question that I saw, and it gets back to my point, and it was, how do you apply it? The drug testing is going to, whether it's a hair follicle or another type of testing, it's still going to have a look-back window of 10 to 30 days. That's clear. And I think, if you have a zero tolerance policy and you're in a state, which most states are, that doesn't prohibit you from having a zero tolerance policy, it seems to me that even if as time passes, the presence of the THC and metabolites in the system are going to diminish. And that's where, if you did have a cutoff, you could be able to assess, how recent was the drug usage to the date of the test, and if it's not a significant level, and if you had a cutoff level that you've identified that you were comfortable with, you could be able to address it that way. I think the key there is, if you're going to make an exception for one person with and you don't have the level, you better be prepared to make that exception for the next person, because it's the inconsistency of the application that's really going to find you in a trick box.
One of the attendees has asked, how can you address a concern about zero tolerance while working, but permissible off-duty conduct? We don't care if you, quote, smoke on your own time. How do you test if the test covers a significant period of time? And I think that's where Bob's comments come in. If you're in a work environment where you've drawn the line of, we're not going to get involved in employees' off-duty conduct, then what you're probably looking at, the most effective policy would be one that sets a level of impairment. And that level of impairment can be based on some of the statutes that are out there now. For example, Colorado's recreational marijuana statute has a provision that discusses what's intoxication while driving if you've used marijuana recreationally. I'm assuming there must be a cutoff point by which one can be arrested for driving under the influence of marijuana. And that's the kind of level that you might want to set in a policy. And certainly probably then a hair test policy is not for you. What you would like would be more of a traditional urinalysis test where you're testing for specific levels of metabolites. And that's really what the point of some of the cases Joel talked about as well. Even in some of those key seminal cases that are up on appeal right now, the marijuana levels actually in the plaintiff's system were so low as to be deemed almost inactive. So it adds to the plaintiffs, these plaintiffs, some of whom are quadriplegics, as we have discussed, their sell to a jury or to a judge that they're really being terminated for off-duty conduct when they were not impaired at work.
One of the questions we got was a hypothetical where a Texas employee, a desk employee, not safety-sensitive position, travels to Colorado for vacation, smokes recreational marijuana on Saturday, comes back to Texas and goes to work on Monday, and is selected for a random drug test and tests positive. And the questioner has asked whether that's grounds for termination. And the answer to that is sure. Yes, if the employer has a policy that wants to terminate them for engaging in illegal activity, absolutely, they can terminate them.
Now, Texas's law, the bill that was just proposed, I apologize to all of you. A bill is not a law, and you have not totally been clear at some points of the presentation. The bill that was just proposed 2 weeks ago does contain one of those clauses, as currently written, that an employer who fails a drug test, employee who fails a drug test for marijuana can't be terminated unless they're actively impaired. This is the very first draft of that bill. It's not even gone to committee as of last week. So it remains to be seen whether that will continue in Texas. Okay, well, we're being told that we are out of time. So we're going to hand this back over to your moderator.
Thank you so much. On behalf of LexisNexis, I'd like to thank Melissa, Joel, and Bob for an outstanding program today. For our attendees, please take a moment to complete the survey, as it provides us with excellent feedback so we can continue to tailor programs that you would like to see the most. Thank you all, and have a great day.